Chapter 3. Definition and Nature of a Trademark. Section 80. A definition of the term trademark is requisite, in order that we may know exactly what we are discussing. This definition is not without difficulty. To arrive at certainty therein, we must examine the laws and the judicial decisions of various countries, whose jurisprudence on this subject is harmonious with that of our own tribunals. Indeed, this species of property cannot advantageously be considered simply in its relationship to a locality, but it must be viewed in connection with affinitive subjects embraced by the all-pervading spirit of commerce. Names sometimes deceive. The difficulty of defining this thing called a trademark has been recognized by the ablest minds. Section 81. We must seek the differential quality by which a trademark is discriminated from its analogues, or we shall find our ideas tripped up by the improper use of names. Nomenclature does not consist in the mere naming of tools, but is the expression of distinctions which convey in a single word the nature of the thing meant. When we use the terms trademark, label, sign, envelope, design, etc., we mention things which are analogues of each other, and are not similar in their natures. Section 82. The exposition of the comprehension of a notion is called its definition, says Sir William Hamilton. For example, the concepts man, horse, dog, and sea are contained under the general concept animal, and the concepts triangle, square, circle, rhombus, rhomboid, and sea are contained under the general concept figure, concept and notion being convertible terms. The same clear thinker says that conception, the act of which concept is the result, expresses the act of comprehending or grasping up into unity the various qualities by which an object is characterized. It has been for lack of a clear conception of the natures of the things which they had occasion to discuss or comment upon, that at times judges, essayists, and reporters have misused terms, and named one thing when they meant another. The uninitiated are misled by the wrongful use of terms, and find to their sorrow, in court, that what they supposed were veritable trademarks, are mere labels or advertisements, not within the pale of the law's protection. The opinions abounding with fallacious obiter dicta remind one of the illustration used by Sir William Hamilton, in countries where banknotes have not superseded the use of the precious metals, large payments are made in bags of money, purporting to contain a certain number of a certain denomination of coin, or at least a certain amount in value. Now these bags are often sealed up, and passed from one person to another, without the tedious process, at each transference, of counting out their contents, and this upon the faith that, if examined, they will be found actually to contain the number of pieces for which they are marked, and for which they pass current. Still the door is open to error and fraud. In the same way, we too frequently accept the loose sayings of a judge for law, because they bear the judicial impress, but when, from abundant caution, we open and examine the bag purporting to contain pure gold, we find but withered leaves. In no unkind spirit, we scan the words that should be the fortresses of thought, and find a heap of chaff. No one has the right to complain of our attempt to separate the chaff from the wheat. Locke tells us, in speaking of the abuse of words, that some take so little care to lay by words which in their primary notation have scarce any clear and distinct ideas which they are annexed to, that by an unpardonable negligence they familiarly use words which the propriety of language has fixed to very important ideas, without any distinct meaning at all. Men having been accustomed from their cradles to learn words which are easily got and retained, before they knew or had framed the complex ideas to which they were annexed, on which were to be found in the things they were thought to stand for, they usually continue to do so all their lives, and, without taking the pains necessary to settle in their minds determined ideas, they use their words for such unsteady and confused notions as they have, contenting themselves with the same words other people use, as if their very sound necessarily carried with it constantly the same meaning. Section 83. Thus, a careless speaker applies the term trademark to a mere label, although such mere label is not protected by law, unless by some local statute, or to a mere advertisement, or to the goodwill of a shop, or to the sign of an inn or hotel. It is true that we may read and analyze for ourselves, and it is quite as true that we accept the phraseology of a judge on trust. The universality of a term, says Watt, in his book on logic, is many times restrained by the particular time, place, circumstance, and c. Or the design of the speaker, as when it is said in the Gospel that all men did marvel, it reaches to only those men who heard of the miracles of our Saviour. By a careful perusal of a case, we may generally ascertain the import of the language of a judge while he is attempting to expound the law. But, unfortunately, we find that he is sometimes completely in the mist. The one exclusive sign, says Aristotle, that a man is thoroughly cognizant of anything, is that he is able to teach it. We may, therefore, conclude that if a judge cannot convey to the mind of another person an intelligent idea of his meaning, he must himself be deficient in the understanding of his subject. We require a definition, and that definition the analysis of a complex concept into its component parts or attributes. Section 84. A definition is a brief enunciation of the law governing a particular subject, or branch of a subject, known by a particular name. Thus, the law of contracts is, in outline, stated in the definition of the word contract. Out of an accurate definition can be drawn a vast amount of law. But, in the nature of legal things, a definition can never be established by adjudication. The absolute truth of this proposition appears when we consider that the object of every lawsuit is, so far as the law of the case is concerned, to determine the rights of the parties as growing out of certain facts admitted or proved. But facts, as shown in courts of justice, are just as variant in nature from a definition as is a triangle from an emanation of the mind. There is no concord or harmony between the one and the other. Yet, although a court cannot adjudge a definition to be so and so, it may, in assigning reasons for its judgment, take into the account the idea of the true principle of a definition. In other words, the judge, in giving the opinion of himself and his associates upon the law as applied to the facts, may state what he and they deem the true definition to be. But this statement is a mere dictum, it creates no law, it is of no higher authority than are similar statements made by text writers, and indeed it is not so likely to be found correct as is theirs. In his treatise on trademarks, Lloyd states his opinion that there would be much convenience in having a statutory definition of a trademark, which should distinguish, as was done by the old French law, between the marques de fabriques, or trademarks properly so called, consisting of a stamp affixed to or incorporated with a manufactured article, and the use of a name, or label, or a signboard, or placard, and all those less permanent marks of distinction which are used in trade, and again separating from them all cases which involve literary or industrial property. Section 85. The French have probably given this subject as keen and thoughtful a scrutiny as any jurists in the world, and yet, in the report of the Commission to examine the project which crystallized into their legislative act of the 23d of June, 1857, it is said, "In what do marks consist? The plan of the law, avoiding the peril of a definition, and leaving to doctrine and to jurisprudence the task of defining, has remained mute in this respect." The Council of State concurred in this idea of the impolicy of attempting an exact enunciation of the elements which constitute this thing, and said, "The mark is any sign serving to distinguish the products of a manufacturer, or the objects of commerce, and the law cannot enumerate the signs." The Court of Paris, in 1859, calls it the characteristic sign by means of which commerce distinguishes the products of one's manufacture, or the objects of his commerce, by resorting to what was until lately the universal language of diplomacy, the French, and which is a safe guide to the meaning of all leading nations when speaking upon this subject. We find that the trademark of English-speaking countries is the same thing as the marque de fabrique de commerce of continental Europe. This is placed beyond all question by the Code International de la Propriété Industrielle, and c. Bum-Patel and Huguet, Paris, 1855, and the Appendix thereto, 1865, by the former eminent jurist. Our term is so translated, and so its synonym in the English Merchandise Marks Act, of 1862. All treaties and conventions of commerce agree in this respect. The uniformity of expression proves that the same thing is understood by all alike, and that in the minds of statesmen and jurists there is no doubt as to what is meant by the general comprehensive term trademark. As corroborating instances of this prevalent understanding, see our treaty with Russia, where the phrase trademarks affixed to merchandise is rendered in the counterpart des marques de fabriques apposées dans l'autre sur certaines marchandises, and c. Also, our conventions with Belgium and France. The German term Fabrikszeichen is translated into the same words in French. We find a more comprehensive definition of the term mark of trade, in German. Section 86. This perfect agreement leads to the inevitable conclusion that a trademark is not a new kind of creature, and that its meaning, purpose, and value are well known to all manufacturing and commercial peoples, and requires no definition in a treaty, every word of which is subjected before ratification to the most rigid scrutiny. The manifest object of the many national compacts was reciprocity of protection, and not to give vitality to the thing. When we come to fully consider the subject, it will be amply demonstrated that, as much as any other species of property, a right to a distinctive mark of authenticity has its foundation in immutable law, and we will perceive that any arbitrary law, as a treaty, a convention, or a statute, cannot be the parent of this ideographic sign. The right pre-existed, a compact only recognizes that right, and opens the door to a remedy for encroachment thereon. Section 87. The mark may consist in the name of the manufacturer or the merchant, provided it be written, printed, branded, or stamped in a mode peculiar to itself, in a seal, a letter, a cipher, a monogram, or any other sign or symbol that can serve to distinguish the products of one man from those of another. It may be any symbol or emblem, however unmeaning in itself, as a cross, a bird, a quadruped, a castle, a star, a comet, a sun, or it may, and frequently does, consist of a combination of various objects, copied from nature, art, or fancy, and if such symbol or emblem comes by use to be recognized in trade as the mark of the goods of a particular person, no other trader has a right to affix it to goods of a similar description. It may be adhesive or non-adhesive. It may be put inside of the article, or on the outside. It may be written, printed, stamped, painted, stenciled, branded, or otherwise, and either on the article itself, or on its case, covering, envelope, or wrapper. Section 88. We must not be misled by a sweeping definition. We must judiciously compare, reason, generalize. Mere words may deceive. The physiology of the thing called a trademark must be examined and carefully analyzed. It is an individuality of nature. Meaningless in itself, when placed in a certain juxtaposition, it involves an idea, as the digit 9 does not represent the word 9, but the idea itself of the number. It is the legitimate hieroglyph. It is the emblem of man, and it virtually says that the vendible object to which it is attached is the workmanship, or the selected article, of the owner of the mark. It is intended to strike the eye by its clearly defined character, and sometimes the ear by its sound when spoken of, and thus excite inquiry, and for this reason it must be peculiar in form, although possibly not susceptible of utterance in sound. Section 89. We may readily understand why a nondescript vignette, a grouping of flowers and fruits, an elaborate landscape having no striking features, or a mere advertisement, or common print of a man's name, should not be regarded as the distinctive mark that the law of commerce requires. It should possess such salient features as might at once arrest attention and put the intended purchaser on the alert. If such an undefined object could possibly be regarded as a valid trademark, what would be the consequences? There would be neither protection for the owner nor guarantee for the buyer, for any other combination of flowers and fruits, of houses and trees, having the same pictorial effect, might be mistaken for it. Section 90. It is not very remarkable that casual readers should fall into the error of confounding the technical trademark of commerce with rights protected upon principles analogous to those upon which trademark decisions rest, such as the goodwill of an establishment of trade and literary rights, especially when we find at times a judge, a commentator, or a reporter, falling into the same error. The importance of observing the distinction will be more manifest as we proceed in this investigation. It should be borne in mind that a trademark carries the idea of a man's personality, like his ordinary autograph, and therefore preserves its essential characteristics wherever it may go. This is not so with a quasi-trademark, as the name of a hotel or shop of trade, or the title of a stagecoach, or mere literary property, or a patent for an invention or a discovery. For such things have no inherent extraterritorial force, and for recognition depend upon compact, or the tacit acknowledgement of nations other than those where such rights originated. Section 91. With rare exceptions, this important distinction is observed. Mr. Lloyd, in his treatise on trademarks, preserves the line between the goodwill of a trade so far as it is contained in the title and style of a partnership, or the name of a trader, or the description of his place of business, and property in a name or distinguishing style, as connected with a literary publication or a work of art. So do also the continental writers and jurists, for although in their tribunals a single action may, it seems, embrace a claim for damages for infringement of a patent, a demand based on a trespass on the goodwill property by false representations, the piracy of a label and violation of a mark, and may unite a demand for both civil and criminal penalties, that is, when all the alleged wrongs shall have arisen from one transaction. Yet we find that the different classes of injuries are separately considered in arriving at a conclusion, although constituting the warp and woof of the same web, and in adjusting remedies each species has its own peculiar redress. This mode of procedure, so different from that of countries under the domination of the common law of England, springs from the flexibility of the Code Napoleon. Yet this complexity need cause no confusion of ideas, except in the minds of superficial readers and unreflecting dabblers in law. Section 92. In the case of Woodward v. Lazar, in the Supreme Court of California, in 1863, before all the justices, the name of a hotel was treated as a trademark. It was an appeal from an order refusing to dissolve an injunction by which the defendants were restrained from using the name of Watcher House as the title or name of a hotel in the city of San Francisco. Norton, J., in delivering the opinion of the court, said, "It has been decided, and with good reason, that the name established for a hotel is a trademark, in which the proprietor has a valuable interest, which a court of chancery will protect against infringement." Howard v. Enriques, 3 Sand, S. C. 725. The point of dispute in the case is as to whom the name Watcher House, as a business sign, belongs. The plaintiff claims that it belongs to him, as the keeper of the hotel, which he continued to conduct under that name after he surrendered the leased premises, while the defendants claim that it is the designation of the building in which the business under that name was first conducted, and became theirs when they became owners of the building. Now let us examine the case cited by the judge, and decide for ourselves whether or not there was not a mistake made in the name of the thing, a mistake quite as wide of the truth as would be the confusion of the terms freehold, mortgage, lease, all relating to landed property, yet distinct in their natures. Names are sometimes things. Section 93. In a Muskeg Manufacturing Company v. Speer, in 1849, a distinguished jurist, Mr. Justice J., inadvertently misused terms. The defendant had pirated plaintiff's label, making it correspond in size, color, fancy border, position, general arrangement and size of the letters, including the alleged trademark, the capital letters, ICA. These letters were decided not to be a trademark, being merely indicative of quality. What, then, was the trademark? Nothing. Compare the language of the two labels. That of the plaintiffs read thus: a Muskeg Manufacturing Company, Power Loom Yards, ACA, a Muskeg Falls, N.H. That of the defendant read thus: Lowell Premium Ticking, Power Loom Yards, ACA, Warranted Indigo Blue. The judge had a clear conception of all the principles involved, and his decision was unquestionably correct. The extraordinary powers of the Court of Equity had been invoked to prevent the continuance of fraud. In what did that fraud consist? In a designed, studied, elaborate imitation of the label of the plaintiffs, said His Honor. The defendant endeavored by a false representation to effect an unlawful purpose. To quote the judge's own words, "In this case there is a fraud coupled with a damage, and a court of equity, in refusing to restrain the wrongdoer by an injunction, would violate the principles upon which a large portion of its jurisdiction is founded, and abjure the exercise of its most important functions, the suppression of fraud, and the prevention of a mischief that otherwise may prove to be unbearable." The remedy could not be denied. The error of the judge manifestly consisted but in the loose use of one word for another, those words being in no sense convertible terms. The words were uttered more than 20 years before the first case of the kind had been reached in the highest court in the land, and were uttered in a case which required no definition of species. If there had been any need of a nice discrimination of technical terms, the acute mind of the judge would have seized upon it, and, by using the exact word, would have prevented the possibility of misunderstanding. The objectionable phraseology was this: when I compare the original trademark of the plaintiffs, and see the correct word was label, not trademark. It must be obvious at a glance to anyone who has acquainted himself with the law and principles of trademarks, that the single element that could possibly be a trademark was the aka symbol. The 3 letters were found not to constitute a lawful trademark, and were stricken from the injunction. Nothing, thereafter, remained but words in ordinary use, common to all the manufacturing world. But, if this was not a trademark case, what was it? Answer: it was a case of unlawful competition in trade, by means of a simulated label. Section 94. In another place it will be seen that the Patent Office took action upon this question, and decided the 3 letters aka to be at least a prima facie trademark, from its long user and universal recognition. Section 95. The case of Howard v. Enriques, in 1851, was decided by 5 out of 6 judges of the Superior Court of the City of New York, when that court was composed of as able minds as any in the land. The plaintiff was proprietor of a hotel known as the Irving House, or Irving Hotel, and which was opened and named by him Irving House, in 1848. The defendants opened another hotel in the same city, which they named the Irving Hotel. An injunction was granted, by one of the justices of the court, restraining the defendants from using the name thus taken by them. A motion was made to dissolve this injunction. Observe, the plaintiff's house, although originally designated by him as the Irving House, very soon became generally known also as the Irving Hotel, and was designated by both names indiscriminately for more than a year before the defendants opened their hotel. All these facts appear in the opinion of the court, delivered by Mr. Justice Campbell. It was urged by the defendant's counsel, first, that the plaintiff had not appropriated the name, because no such name appeared on the external walls of his house, and, second, even if it did so appear, the name was not the subject of appropriation, as applied to a hotel, that the principle upon which trademarks and other similar rights had been protected, was applicable alone to personal property, to manufactured articles, to such things as were necessarily movable, and in reference to which frauds could be practiced without being easily detected, or, at all events, frauds could be practiced operating injuriously upon the party claiming the trademark, and also upon the public. The answer of the court was that there would be no more necessity for the plaintiff to place in large letters upon the front of his building, "This is the Irving House," in order to designate it and secure an appropriation of the name, than there would be to write on the public edifices of the city, "This is the City Hall, and this is Trinity Church." As to the second objection of the defendants, the court spoke thus: "We think that the principle of the rule is the same, to whatever subject it may be applied, and that a party will be protected in the use of a name which he has appropriated, and by his skill rendered valuable, whether the same is upon articles of personal property which he may manufacture, or applied to a hotel where he has built up a prosperous business. We are not disposed to interfere with the lawful pursuits of any one. Every man may, and ought to be permitted to pursue a lawful calling in his own way, provided he does not encroach upon the rights of his neighbor or the public good. But he must not by any deceitful or other practice impose upon the public, and he must not, by dressing himself in another man's garments, and by assuming another man's name, endeavor to deprive that man of his own individuality, and thus despoil him of the gains to which by his industry and skill he is fairly entitled. To make the application, if one man has, by close attention to the comfort of his guests, and by superior energy, made his hotel desirable for the traveler, and caused its name to become popular throughout the land, another man ought not to be permitted to assume the same name in the same town, and thus deprive him who first appropriated the name, of some portion of the fruits of that goodwill which honestly belongs to him alone. Section 96. The perusal of this case of Howard v. Onreeks relieves the mind from all doubt or embarrassment as to the meaning of the court. The counsel had been reasoning from analogy, and the court pursued the train of ideas thereby evolved. No one in that case assumed that the mere name of a hotel could be a trademark, but argued upon principle. How could anyone so assume? Did the proprietor of the name affix it to any vendable article, number? But, it may be replied, he did use it upon all the bills rendered to his guests, on cards, and in numerous advertisements circulating throughout the country. True, but advertisements are not trademarks. Nothing short of the sheerest sophistry could twist the title of a hotel into a mark of commerce, a visible mark affixed to a thing sold, or for sale. We cannot detect the essential elements of the thing technically so known. Then, if not a case of trademark, what was it? It was exactly what the Superior Court, by the lips of Mr. Justice Campbell, called it: the goodwill of the establishment. The case did not call for a definition. All that was required was substantial justice, upon the allegation of an invasion of an equitable right. Section 97. Mccardelle v. Beck, before the Supreme Court of New York, in Bank, in 1864, is a case that is sometimes cited to prove that the name of a place of business is a trademark. The misconception is the fault of the syllabus of the reporter. The matter in dispute was the right to use the name of a restaurant known as the Mccardelle House, in the city of Albany. The court certainly did not treat the case as any other than a question of the right to the goodwill. The language of Miller, J., who delivered the opinion, misled the reporter. He said, "The use of names and trademarks in business, when made valuable, has always been protected by the courts, and any improper appropriation of them without the authority of the owner will be restrained by injunction." He said in another place, "The use of a name or trademark." This is all that was said of trademarks, names and trademarks, and a name or trademark. It needs no great power of discrimination to perceive that the employment of the conjunctions implied a distinction between name and mark. Section 98. Howe v. Searing, 1860, is another case that is quoted in support of the theorem that the name of a place of business is essentially a trademark. But a careful examination of that case will show that the majority of the court placed it in its proper category. The plaintiff, a baker by trade, brought an action to restrain the defendant from designating the bakery establishment kept by him, in the city of New York, as Howe's Bakery, and from otherwise using the name of Howe, so as to induce the public to believe that the business carried on at his place was conducted by the plaintiff. It was not in any wise discussed as anything other than what it really was: the goodwill of the business of baking. All the authorities commented upon by the learned Judge Hoffman, who delivered the opinion of the court, are goodwill cases. He adopted the language of Vice-Chancellor Wood, in Clinton et al. V. Douglas. The name of a firm is a very important part of the goodwill of the business carried on by the firm. A person says, "I have always bought articles at such a place of business, I know it by that name, and I send to the house of business identified by that name for that purpose." Moncrief, J., dissenting, said, "The name or words Howe's Bakery was nothing but a trademark, and, as such, is now sought to be protected by the plaintiff." The name or trademark passed by the assignment and transfer of the goodwill, and, if it was not the thing itself, it was an integral part of it. Section 99. What warrant had the dissenting judge to use the technical term trademark? We look in vain for any authority to sustain his remark. Consider the circumstances. The plaintiff, who had been doing a lucrative business as a baker at number 432 Broadway, sold the lease of the premises, with all the stock, wagons, and fixtures, and the goodwill of the concern, to one baker. Baker subsequently sold back to Howe the right to resume business at another place, number 850 Broadway, in the same city, and still later sold the lease to Searing, the defendant, subject, however, to Howe's right to conduct business in his own name. Searing continued the old sign name, to the prejudice of the plaintiff's rights, and in a way calculated to mislead the public. Howe had a clear title to his own name, and so, indeed, had any other Howe the same right, and if he chose could put up a sign informing the public of the location of his place of business. Searing, the defendant, had no right to use Howe's name. Hence the suit. The mere name of Howe could not be a valid trademark, for it was not the exclusive property of the plaintiff. It was not a trademark unless intended to be stamped upon, or otherwise affixed to the articles sold. It was at best a mere advertising sign. Even if stamped upon the bread, it would not be a trademark, for it would not indicate origin. The purchasers could not tell by the mere name what one of many persons of the same name had baked the bread. Conclusion: the remarks of Mr. Justice Moncrief were not a judicial decision, and must be classed with unauthoritative obiter dicta. Section 100. We must not infer from the foregoing decisions that the name of a place of business cannot become a valid trademark if it possess the true characteristics of such a mark, if it be not generic, merely descriptive, or one that any other person in the same trade may truthfully use, and if it be affixed to a vendible article, then it may be made a trademark as well as any other symbol. The case of Choinsky v. Cohen, in the Supreme Court of California, in 1870, before all the justices, is in point. The plaintiff claimed the exclusive right to the name, Antiquarian Bookstore, which name was placed upon his sign, stamped upon all articles sold by him, and used in his correspondence. Held to be a mere designation of trade. Section 101. It was of little or no moment in the cases cited what term a judge may have used to express an idea. Substantial justice did not depend upon preciseness of terminology. It is, however, of moment in our present purpose to accurately define, lest by looseness of language we fall into looseness of application of principles, and so end in egregious error. In judicial matters, a rose by any other name may not smell as sweet. A name is sometimes of the very essence. We could not arrive at any result other than this: the name of a hotel and a trademark are not convertible terms. Section 102. The British Merchandise Marks Act, of 1862, says that the word mark shall include any name, signature, word, letter, device, emblem, figure, sign, seal, stamp, diagram, label, ticket, or other mark of any other description, and the expression trademark shall include any and every such name, signature, word, letter, device, emblem, figure, sign, seal, stamp, diagram, label, ticket, or other mark as aforesaid lawfully used by any person to denote any chattel, or, in Scotland, any article of trade, manufacture, or merchandise, to be an article or thing of the manufacture, workmanship, or production, or merchandise of such person, or to be an article or thing of any peculiar or particular description made or sold by such person, and shall also include any name, signature, word, letter, number, figure, mark, or sign which in pursuance of any statute or statutes for the time being in force relating to registered designs is to be put or placed upon or attached to any chattel or article during the existence or continuance of any copyright or other sole right acquired under the provisions of such statutes or any of them. This language savours more of enumeration than definition, and may possibly mislead by its breadth of expression, embracing as it does things incongruous in their several natures, as registered designs and copyright matters. Being a statute applicable only to British courts, its form of expression cannot be taken as an infallible guide for our present purpose. Many of the terms used cannot be understood unless taken with their judicial definitions, as name, word, label, and see. It should, however, be observed that the expression trademark not only includes every mark lawfully used by a person to denote any chattel to be an article of the manufacture, workmanship, or production of such person, but also to be an article of the merchandise of such person, or to be an article of any peculiar or particular description made or sold by such person. This will include such cases as Motley v. Downman, where it was contended that the right to use the trademark was attached to a particular place and works, and to cases where the articles are distinguished by the name of a person who did not manufacture them, and to similar cases. Section 103. Is the name of a newspaper a trademark? This question has been thoroughly discussed pro and con in the Patent Office, but has probably not been definitively decided by any court. Upon an application for registration, all the authorities bearing upon this point were examined. If a technical trademark, the application would be favorably acted on; if not, it would be rejected. The matter being ex parte the pleasing task of collating judicial decisions devolved upon the office. We will let the cases cited again pass in review. Section 104. Snowden v. Noah, in the Court of Chancery of New York, before Sandford, Chancellor, in 1825, was treated by counsel and by the court as a Goodwill case. The Chancellor said, the defendant Noah was the editor, but not the proprietor, of the newspaper establishment called the National Advocate, and immediately after the sale of that establishment by its former proprietor to the complainant, Noah established another newspaper, under the title of the New York National Advocate. This new gazette thus established is sent to the subscribers of the former National Advocate, and Noah has solicited and continues to solicit the support of the patrons of the former paper and of the public to his newspaper. This is briefly and in substance the case upon which an injunction is now asked. After some other remarks, he continued, the subject in respect to which an injunction is asked, is what is called the goodwill of the establishment, or the custom and support which the National Advocate had before received from its subscribers and patrons, or from the public. The effort of Noah is to obtain for his newspaper the support of the public in general, and especially the custom and goodwill of the friends of the National Advocate. This object is distinctly avowed, and an open appeal is made to the friends of the National Advocate and to the public to give their support to the new paper. The question is, whether the acts of Noah are an invasion of the private rights of Snowden, as the proprietor of the National Advocate, or merely an exercise of the common right to print and publish a new journal, and to obtain for it patronage. The only circumstance in this case which has any appearance of an undue encroachment upon the rights of Snowden is, that Noah's new paper is published under a name nearly the same with that of Snowden, but the name of the new paper is sufficiently distinct from the name of Snowden's paper to apprise all persons that these are really different papers. I do not perceive that any person can be misled in this respect. The goodwill of an established trade, the custom of an inn, and the right of a publisher of books, may be injured by acts of deception and piracy. But the injury for which redress is given in such cases results from the imposture practiced upon the customers of an existing establishment, or upon the public. It is evident that the Chancellor did not contemplate the case as a mere infringement of a trademark right, or he would not have mingled the matters of an injury to trade, to the custom of an inn, and the right of a publisher of books. If he had regarded the name National Advocate as a trademark, then he must necessarily have passed upon the question, whether the name that the defendant had adopted was not an infringement of that trademark. Yet he chose to discuss the question in controversy under the comprehensive idea of an injury to the goodwill. Therefore that case does not solve our inquiry. Section 105, Bell v. Locke, in the same court, before Walworth, Chancellor, in 1840, was a similar case. This case came before the court upon an order for the defendant to show cause why an injunction should not issue, restraining him from printing, publishing, or circulating a newspaper under the name of the New Era, it being contended that such name was an infringement of the rights of plaintiff, who published the Democratic Republican New Era. The Chancellor, the allegation in the complainant's bill is, that the defendant has assumed the name of the complainant's newspaper for the fraudulent purpose of imposing upon the public, and supplanting him in the goodwill of his established paper, by simulating the name and dress thereof, with the intent to cause it to be understood and believed by the community that the defendant's newspaper was the same as the complainant's, and thereby to injure the circulation of the latter. If this were in fact so, I should have no difficulty in making this order absolute. He observed, further on in his opinion, that there could be very little excuse for the editor of a new paper who should adopt the precise name and dress of an old established paper, which would be likely to interfere with the goodwill of the latter by actually deceiving its patrons. This case comes closer to our notions of one involving the mark of trade or commerce, and although the Chancellor used the term goodwill and did not mention the term trademark, we conclude that the latter term was strictly applicable. Section 106. In Dayton v. Wilkes, at a special term of the Superior Court of the City of New York, in 1859, Huffman, J., in regard to the right to use the name of Porter's Spirit of the Times, said, "It has been very correctly argued, by the counsel for the plaintiff, that the analogy of the rules as to trademarks should apply to this case. It is manifest that the court did not regard the thing in controversy as a mere trademark, nor was it necessary for the solution of the matter. We must look further. Section 107. Matsell v. Flanagan, at a special term of the Court of Common Pleas, in 1867, is of assistance in elucidating the mooted question. The plaintiffs were, and had long been, the publishers and proprietors of the National Police Gazette, which was commonly known to the public as the Police Gazette. The defendants prepared and published a newspaper, in imitation of the plaintiff's newspaper, with nearly the same title and device, which misled and deceived purchasers. So the complaint alleged, and so the court found. The language of Brady, J., relieves us from any doubt as to the class of wrongs to which he assigned a case of the kind. After reciting the power of the court in trademark cases, he continued, "The enforcement of the doctrine that trademarks shall not be simulated does not depend entirely upon the alleged invasion of individual rights, but as well upon the broad principle that the public are entitled to protection from the use of previously appropriated names or symbols, in such manner as may deceive them, by inducing or leading to the purchase of one thing for another." This case was treated as purely an infringement of a trademark, and the court, in commenting upon Snowden v. Noah and Bell v. Locke, treated it as a parallel case. Section 108. Stevens v. Canto, at a special term of the Superior Court of the City of New York, in 1868, has a somewhat different complexion. The plaintiffs owned and published a newspaper called La Cronica. The single question in controversy was as to restraining the publication by the defendant of the paper called El Cronista. Monell, J., discussed some of the general principles of goodwill, and assumed the case to be of that nature, if indeed any right at all existed, and, in delivering his opinion, he wandered off into fields foreign to the real nature of the case presented. He said, if this case was to be determined solely upon whether the similarity, if it could be established there was any, of the names, La Cronica and El Cronista could mislead the public into the belief that they were the same, I should have no difficulty in reaching the conclusion, upon the evidence, that no such effect could or would result. I do not understand that the protection which the law affords to trademarks, even assuming the name of a newspaper to be a trademark, goes so far as is claimed in this case. The protection which has been granted to that species of property has never, I believe, been extended over anything that was the subject of a patent or a copyright, but is confined to appropriations of names designating some particular manufacture or business. There can be no such property in a newspaper, which is the only continuing portion of it. The contents of each issue are the composition or creation of the editor or contributors, are varied each day, and when given to the public all literary proprietorship in them is lost. And the law of trademarks, like the law of copyright, cannot be applied to a work of so fluctuating and fugitive a character. Clayton v. Stone, Payne, 392. I do not mean to say that a newspaper proprietor cannot appropriate, and, by long use, acquire a property in a name, which the courts will protect against piracy. In this respect the analogy of trademarks would apply. Dayton v. Wilkes, 17 How, Pr. 510. And I have no doubt that the names, so long appropriated and used, of, the New York Herald, or the Sun, would be protected as trademarks, against the assumption of those names by another proprietor, but that I understand to be the extent of the rule, and that any mere assimilation of the name, unless it was clearly to deceive the public, would not be unlawful. The injunction was accordingly dissolved, and the complaint dismissed with costs. This opinion has been quoted a number of times on each side of the question, which is evidence that it has misled. Let us hastily analyze it. What was the point? It was this: was the use of the name El Cronista an infringement upon the exclusive right in the name of another newspaper, La Cronica? The general contents of the respective papers had nothing to do with the contest. The judge said the protection given to trademarks had not been extended over anything that was the subject of a patent or a copyright. Nothing more true. But the name of a newspaper is not the subject of a patent or of a copyright, as we shall see hereafter in this treatise. But the judge expressly conceded that the long-used names of certain papers would be protected as trademarks. That is our case. so far as this decision goes. With it has exhausted our American authorities on this point. We look in vain for an English case that exactly touches the present question. Hogg v. Kirby was cited in each of the foregoing discussions, but it does not help us in reaching a determination. In no instance have we the opinion of more than one chancellor or judge. Let us think whether the true principle cannot be deduced therefrom. Section 109. The question recurs: is the name of a newspaper a trademark? If not, upon what principle is it protected? The question arose in the Patent Office upon an application to register the name of a paper. It was suggested that, as the name had been copyrighted, protection must be sought under Section 86 of the law in relation to copyrights. It is there provided, that any citizen of the United States, or resident therein, who shall be the author, inventor, designer, or proprietor of any book, map, chart, dramatic or musical composition, engraving, cut, print, &c., may, upon complying with certain specified conditions, have the sole liberty of printing, publishing, and vending the same. And c. The heading of said paper consisted of an ornamental engraving on wood, commonly known as a woodcut. It was also a print. Did those literal facts determine the right? We will examine for ourselves. The Librarian of Congress, not being a judicial officer in any sense, was not required to pass upon the legality of copyrighting the thing presented to him for that purpose. The fee was paid, the act was done. But does a mere newspaper heading come within the spirit and meaning of the law? The Constitution gives power to Congress to promote the progress of science and the useful arts, by securing, for limited times, to authors and inventors the exclusive right to their respective writings and discoveries. We can nowhere else find the power to legislate upon copyrights. The rights of inventors and authors, as long settled in Great Britain, were familiar to the framers of the Constitution, and, as Mr. Justice Story says, it is doubtless to this knowledge of the common law and statutable rights of authors and inventors that we are to attribute this constitutional provision, being beneficial to all parties. It was beneficial to authors and inventors, because it maintained their rights to the product of their intellectual labor, and beneficial to the public, as it would promote the progress of science and the useful arts, and admit the people at large, after a short interval, to the full possession and enjoyment of all writings and inventions without restraint. In short, the only boon which could be offered to inventors to disclose the secrets of their discoveries would be the exclusive right and profit of them, as a monopoly, for a limited period. A copyright is limited by time, a trademark is not. A copyright is limited territorially, but a trademark acknowledges no boundaries. They are unlike in their natures. Section 110. Literature, invention, and the fine arts needed a fostering hand, and found it. The consideration paid by them for a monopoly was a surrender to the public after a limited time. The consideration was the coin of their brains. Authors. What claim has the adopter of a trademark to be considered an author? He may adopt any symbol, the sign of anything in heaven above or in the earth beneath. It may be a representation of a real object, or it may be entirely fabulous. It does not require any genius for one to call a newspaper by the name of sun, moon, or star. The name of a newspaper is assigned to arrest attention, as it catches the eye. It points to something else. The heading is not offered for sale. Its office is simply to inform the public that the paper on which it is printed is the Herald, the Sun, or the Globe, as the case may be. The public care not a straw whether the heading be ornamental or plain, for the advantage in buying it is the intelligence, the editorials, the advertisements. The purchaser does not glance at the heading, the title, the name, except to be assured that he is getting the newspaper of his choice. He takes no delight in gazing upon the name or heading as a work of art. But the copyrighted article is the thing that is sold. The book, the map, the dramatic composition, the engraving, cut, photograph, &c., is the thing bought. The name of a newspaper is but the guide to the thing. In the case of the heading of a newspaper, if its owner should elect to abandon it after a certain period, what value would he render to the public? Nothing. If considered as a work of art, what would be the measure of damages for infringement? As a penal law, the statute must be strictly construed. Again, it would be absurd to suppose that Congress intended to include such a thing, from the requirement of deposit in the mail before publication, a description of the article, and within 10 days after publication the transmission of 2 copies to enrich the library of the nation. The heading of the Herald is a work of art. We cannot conceive a mere newspaper heading to be a subject for copyright. Section 111. In Stevens v. de Canto, the judge mentioned the subject of a patent, meaning, doubtless, a design patent. Is such a heading the subject of a patent? Examine. Mr. Upton, in his work on trademarks, has taken the correct position in the construction of the Act of 1842, for patents for designs, the language, any new and useful pattern, or print, or picture, to be either worked into or worked on, or printed or painted or cast, or otherwise fixed on any article of manufacture, and c. has been relied on as conferring a right to an exclusive privilege that may be made to serve the purpose of designating articles of merchandise. He says, it is quite obvious that such was not the purpose of the law, but, on the contrary, it was manifestly intended that the design for which such protection was provided, should constitute a portion of the manufactured article, either as an ornamental adjunct, or as controlling its figure or proportions, by no means as a mere name or designation by which to identify or distinguish the article. He maintains that the right thus acquired is in no sense a trademark property. We must agree with him that the construction sometimes given to that act was quite unwarrantable. The design that is patentable is aesthetic. The mark of manufactures or of commerce is not essentially a thing of taste. The abstract symbol has no intrinsic value. The value is in the article to which it is affixed. Section 112. The Supreme Court of the United States in its first trademark case, in 1872, said, property in a trademark, or rather in the use of a trademark or name, has very little analogy to that which exists in copyrights, or in patents for inventions. Section 113. In Swift v. Day, Robertson, Ch.J., said, a patented design may be adopted as a trademark, by consent of the patentee, and thereby its use by others for the same purpose prevented. There is no rule, however, which makes the test of the infringement of such rights the same in both cases. The defendants may be liable in both the federal and state courts, in the former, for imitating the design, in the latter, for passing off, by means of such design, spurious wares as being the plaintiffs, and the cause of action would clearly not be the same. Section 114. Paxson, J., in the Dixon Crucible Company v. Guggenheim, expressed an opinion that the name of a newspaper is a trademark, as much so as a label stamped upon a bale of muslin, although it is true that that was not the exact question before the court. Section 115. From the foregoing train of reasoning, we deduce this conclusion: a newspaper, being a vendible article, is as much a matter of merchandise as anything can be. It would not be bought unless it contained or bore an authenticating sign. That sign is its name. Each issue may be ephemeral, and be at once consumed, but the name, its emblem, is permanent and invariable, and is the stamp of genuineness. We see, therefore, that the office was unquestionably right in admitting the name of a newspaper to registration as a trademark. Section 116. Trademarks on books. Can printed books be protected by trademarks? Yes, as mere merchandise. No, as literary productions. They are articles of manufacture, and may bear a particular mark to designate their author, or the merchant who sells them. Sometimes they are impressed with a peculiar symbol, to indicate the place of sale, but not so much so as in preceding ages, especially the 16th and 17th centuries, and the earlier portion of the last, for then every shop had its emblematic sign, as a dolphin, a lion, the king, and sea, and a representation of that sign indicated the place of sale quite as well as could the name of the merchant or publisher. The mark of the dolphin, for example, would satisfy the purchaser, for he would reflect that he had always obtained correct editions of books at that place. The dolphin. In Savery's Dictionnaire universel de commerce, we find that in France, and probably in other European countries, the legalized mark of a bookseller was an image placed by him under the title of a book, or on the first page thereof. This establishes the fact that books were regarded as proper objects for the reception of trademarks. Section 117. But it must be borne in mind that it is as merchandise merely, and not as intellectual creations, that books are protected by the mark of commerce. Why so? Because a book, as such, has its protection under the copyright law. If a printed, ample remedy is afforded by the copyright law of July 8, 1870. That is the security which the Constitution and the statute provide for infringement upon works of literary genius, even though the pirate change the title of the book, and, as it were, hoist a false flag. It is the contents of the book that would be copied, and not its emblem, title, or mark. Section 118. There seems to be no sufficient reason why the title of a book may not be deemed a valid trademark, e.g., when, 2 centuries ago, in England, the 5 Presbyterian divines, Stephen Marshall, Edward Calamy, Thomas Young, Matthew Newcomen, and William Spurstow, combined the initials of their names, which made the word SMECTIMUS, and adopted it as their joint signature. They had a valid trademark if they had chosen to use it as such. It was good for the publication bearing that name, and would be entitled to protection as a trademark for any books the owners of the newly coined word might offer for sale. Section 119. Here is a case which is usually classified with trademark cases, but, if we keenly scrutinize and analyze for ourselves, we may conclude that, although of the nature of a trademark, the thing in controversy has but little claim to the name. We examine Williams v. Johnson, before the general term of the Superior Court of the City of New York, in 1857. Under the principle that a rose by any other name may smell as sweet, the court contented itself with rendering substantial justice, without caring about too much nicety in terms. We will soon be able to answer this pertinent question. Is not this an instance of unfair competition in trade, by means of false labels? A wrong was done. Let us try to name it. Section 120. The plaintiff alleged that, in or about the year 1845, he and his brothers were manufacturers of soap at Manchester, Connecticut, and made a particular kind of soap, to which, in order to identify it as their manufacture, they gave the name of genuine Yankee soap. It was made in cakes of about 2 inches square, each cake covered with tin foil. Upon one side of each cake was attached an octagonal pink label, with the words printed thereon, "Genuine Yankee Soap, manufactured at Manchester, Connecticut, by Williams and Brothers, chemists and apothecaries." To prevent counterfeits, their signature will be upon each cake. Upon the other side of each cake was attached another octagonal pink label, with the words printed thereon. The genuine Yankee soap is warranted superior to any foreign compound for shaving and the toilet, affording a copious and heavy lather, which does not dry on the face, leaving the skin soft and smooth. And at one end of each cake was attached another pink label with the words in writing, or in resemblance to writing, "Williams and Brothers." The said soap was put up in pasteboard boxes, containing 1 dozen cakes each, and each box was covered with a brown paper wrapper, with the words thereon, "1 dozen genuine Yankee soap, warranted superior to any foreign compound for shaving and the toilet. Manufactured at Manchester, Connecticut, by Williams and Brothers, chemists and apothecaries." To prevent counterfeits, their signature will be upon each cake. Section 121. It was alleged that the defendant manufactured soap of an inferior quality, put up in a style and manner precisely similar to the plaintiff's, that it was cut up into cakes of the same size as those of the plaintiffs, each cake encased in tin foil, and upon each cake were 3 labels of the same form as the plaintiffs. Upon one were printed the words, "Genuine Yankee Soap, manufactured at New York, by L. Williams and Company." To prevent counterfeits, their signature will be upon each cake. Upon another were printed the words, "The genuine Yankee soap is warranted superior to any foreign compound for shaving and the toilet, affording a copious and heavy lather, which does not dry on the face, leaving the skin soft and smooth." And upon the third were the words, "In writing, or in a resemblance to writing, L. Williams and Co." Each box was covered with a brown paper wrapper, with the words thereon, "1 dozen genuine Yankee soap, warranted superior to any foreign compound for shaving and the toilet." Manufactured by L. Williams and Co., New York. To prevent counterfeits, their signature will be upon each label. Upon these several labels the arrangement of the lines, the form of the letters, and style of printing were, in almost every particular, an exact copy of the labels used by the plaintiffs. It was further alleged that the name of L. Williams and Company was fictitious, and used to deceive. Section 122. The defendant's answer denied that the plaintiffs had any exclusive right to use the designation genuine Yankee soap, averring that that term described a particular style and quality of soap, and did not identify the person or persons by whom, or the place where, it was manufactured, and that the article known in the market by that name had been for years manufactured by different manufacturers of soap in different parts of the United States, and sold by that name, and could not be appropriated by the plaintiffs. It further denied that the name L. Williams and Company was fictitious, or used as a color label imitation, assimilating the trademark of the plaintiffs, and deduced the title of the defendant to its use from a firm of that name, who had assigned the business and name to the defendant. Section 123. An injunction was granted its special term, restraining the defendant from selling, or in any way disposing of any soap in boxes or otherwise, with labels or wrappers containing the words genuine Yankee soap printed or written thereon, and from advertising, selling, or offering to sell, any soap whatever, unless the same has been manufactured by or procured from the plaintiffs, as and for the genuine Yankee soap, and c. From the order so made, the defendant appealed. Section 124. In delivering the opinion of the court in Bank, Woodruff, J., said, the defendant is engaged in a gross and palpable endeavor, by imitating the marks and labels used by the plaintiffs, to deceive the public, and obtain patronage which would in all probability be attracted to the plaintiffs. This the defendant is doing, not only by closely imitating the plaintiff's marks and labels, but by falsely representing his soap as a Yankee manufacture, and made by persons named Williams, when, in truth, it is made in the city of New York by the defendant, William Johnson. After characterizing the acts of the defendant as a fraud upon the plaintiffs, the learned judge said of the latter, they have adopted, in reference to their manufacture of an article which any and every one may manufacture and sell, if he please, a form and size of cake, a particular mode of covering and packing, a combination of 3 labels on each cake, an exterior handbill upon the box, and have so arranged the whole as to suggest to anyone desiring to purchase their soap, upon an inspection, that the article is theirs, and made by them, like that heretofore made, sold, and known as their manufacture. All this the defendant has copied, with an exactness which is calculated to deceive even the wary, much more to entrap those who are not in the exercise of a rigid scrutiny. It is true that the defendant has put upon his labels New York as the place of manufacture, and L. Williams & Co., instead of Williams & Brothers, as manufacturers. But the latter designation imports a falsehood, and tends rather to create than destroy the impression that the soap is made by the plaintiffs, and the use of the word New York, in its obscure printing, if it be read, falls far short of suggesting to the public that it is not the soap manufactured by the plaintiffs. Whether upon taking the proofs in the cause it will appear that the particular words, genuine Yankee soap, are to be deemed descriptive of the kind of soap which anyone may make and sell by its proper name, or are terms properly designating the plaintiff's manufacture, and so to be descriptive of their peculiar skill in making an article already in known and common use by its proper and only generic name, soap, is perhaps not free from doubt. It is quite clear that so far as it indicates the place of manufacture, it is a fraud on the part of the defendant to use it. Without deciding whether the defendant may or may not use either of the words genuine or Yankee in any possible combination, we think it sufficient to say that he may not use the labels, or devices, or handbills which he is using, nor any other like labels, devices, or handbills used by the plaintiffs, as set forth in the bill of complaint, or any other similar labels, devices, or handbills calculated to deceive the public, or create the belief that the soap he sells is the soap made or sold by the plaintiffs under the name of genuine Yankee soap. Section 125. A nutshell could contain this case, so far as trademark law is concerned. None of the words on the plaintiff's labels are susceptible of being turned into trademarks, except genuine and Yankee. The court did not decide their nature. It was not necessary so to do. We are warranted in going one step farther. Neither of those words can be made a trademark, nor are they such when combined. Section 126. In the endeavor to ascertain the true nature of a trademark, we will examine the Leather Cloth Company v. The American Leather Cloth Company. The plaintiff's alleged trademark reads as follows: Crockett International Leather Cloth Company, Newark, N. J. U.S. A. West Ham, Essex, England. Which words formed a circle? Within and near the top of that circle is the representation of an American eagle, with outstretched wings, and, over the eagle, the word Excelsior. Below the eagle are the words, Crockett and Company. And leather cloth. Patent is Janney. 2456. J. R. and C. P. Crockett, manufacturers. Plus 12 yards. Plus. Besides that, within the circle are two other similar crosses, and this character from the printer's font. Section 127. To enable a party to obtain the intervention of a court for an infringement of a trademark, he must first establish the fact of his having a trademark. He cannot apply that name to anything that he chooses, despite its utter lack of suitableness for the purpose. The law will examine and apply the proper term of the thing presented. Now, what is the essential constituent element of this stamp? Is it the eagle, the words, or both? We must not be misled by the application of the term trademark to the whole stamp, or label, even by a court. In the House of Lords, on appeal from the Lord Chancellor, Lord Cranworth said, the plaintiff's trademark, if trademark it is to be called, is contained in a circle. Each of the trademarks, it is true, as well that of the plaintiffs as that of the defendants, contains within its periphery an eagle, but not at all resembling each other. The rest of the device, if it is to be called device, consists merely of words intended to indicate the nature or quality of the article, the place of its manufacture, and the names of the manufacturers. Lord Kingsdown, in the same case, uses this language, the plaintiff's trademark, or what they call such. And c. It is undeniable that he used the term trademark to indicate the subject before the court, but it was not necessary to define that particular subject. The term was a convenient one by which to express the collocation of words and the eagle. The real question under consideration was, whether the defendants had been guilty of a fraud upon the public, in selling their goods as the plaintiffs. The Lord Chancellor, whose decision was in process of affirmation, then rose to speak. His language, as to the matter of defining, relieves us from embarrassment. He saw the necessity of giving the alleged trademark its true name. He said, I am satisfied that I assigned for my decision in the court below a ground narrower than I might have taken as the basis of that judgment. There were circumstances which induced me to think that it was necessary to consider the case from the particular point of view which I adopted, and having found that the ground was sufficient for the judgment which I gave, I did not enter into the consideration of the wider view of the subject, which has been so forcibly urged by my noble and learned friends. But, in truth, my lords, not only do I concur with them, but I am satisfied that I ought to have regarded this affix to the plaintiff's goods, which is here denominated a trademark, as something which, according to the anterior usage and application of the word trademark, by no means resembles or comes within the description of anything that has hitherto been properly designated by that name. What is here called by the appellants a trademark is, in reality, an advertisement of the character and quality of their goods, and, dropping for a moment all reference to the incorrect and untrue statements contained in that advertisement, I will take only what is called the trademark of the plaintiffs and the rival or antagonistic trademark of the defendants, and compare them together, taking them as if they were simply, what in reality they are, two advertisements, each affixed, by way of label, to the articles manufactured by the parties respectively. The advertisement is the sole foundation of the plaintiff's case, and their allegations must be reduced in substance to this, that having advertised and described their goods in a particular manner, the defendants have borrowed their advertisements and described their goods in substantially the same manner. Section 128. What language could more clearly convey the idea that, independent of the two eagles, there was not one ingredient of a real trademark in either of the labels presented? The distinction between a mere advertisement and the technical commercial emblem is important. Section 129. An abstract right in a symbol has no existence. The subject must be considered in its concrete relation. Herein a trademark differs from a patent or a copyright. The former exists the instant it is issued, and the latter as soon as entered. The patentee, or the author, may not choose to immediately avail himself of the benefits of the grant, and still the right exists in full vigor, unless, of course, the invention or the book be dedicated to public use by abandonment. But the registry of a trademark does not ipso facto make the mark, but merely operates as evidence of adoption, and the right to it is inchoate, and does not become a perfect right until the owner consummate his intention and stamp the symbol upon an article of merchandise which he desires to sell. When that is done, he will have entered into possession of the exclusive right to affix that particular symbol to the class of goods to which it has been appropriated. The symbol and the article for sale are complements of each other, and it would be as illogical to term such symbol a trademark before affixing it to goods in trade as to term one's loose autograph his signature, although the exact representation of the signature which he intends to apply to an instrument in writing. Section 130. A trademark is nothing more nor less than one's commercial signature to his goods, and the mark and the goods bear the same relation to one another as do the positive and the negative forces of electricity to each other, and in their opposition they mutually uphold and sustain. We must be cautious to discern between things whose natures differ, and assign to each its peculiar and appropriate sign, by words which fit close to the thoughts, or the mind will be confused by a jumble of marks of commerce, of patented designs, of copyrights, of labels, of advertisements, and other matters of incongruous natures. A definition should instantly convey the true idea of the thing, and indicate the precise species of a genus. A trademark is in its nature separate and distinct from everything else in the world, and yet we frequently hear of writers, lawyers, judges, by the most heedless use of the term, leading others into error. Things must be called by their right names. A homicide may mean a murderer amenable to criminal law, or he may be one whose action was justifiable as necessary to the preservation of his own life, or a sheriff reluctantly carrying into execution the sentence of a court, or a soldier in the performance of imperious duty. Astrology, in its etymological signification, is the science of the stars, and among the ancients it was synonymous with astronomy, yet no thoughtful person would confound the two terms at the present day. Before the nice distinctions connected with the law of trademarks were well understood, learned jurists, who adorned the bench, might have been pardoned for ambiguity of expression, in confounding labels and marks, but the time for palliating such carelessness is past, and the particular symbol of commerce must be carefully distinguished from its analogues. Section 131. The Seolist asks, why need we seek the technical name? Cannot justice be applied under one name as well as under another? Rights are rights, says he, whatever name they bear, and the tendency of this utilitarian age is towards simplification, so that one comprehensive term may signify many things. Now, what necessity is there for the loose, indefinite application of a scientific designation, so that it may signify many things, perhaps of natures very unlike? It may be, indeed, that in some cases the paucity of terms of art or science compels a plurality of uses for one word, but as regards our present subject, no such necessity exists. We must be exact in specifying the name of any kind of legal right, in order to obtain the remedy that the law prescribes for a given case. Generic terms must be avoided. For example, in a statute to punish horse stealing, we would not use horse and animal as convertible terms, for the word animal might mean a cow, a sheep, a hog, or a dog. To prevent confusion, we must say exactly what we mean. We would not charge a person with the commission of a crime, but would specify the exact offense imputed to him. We must seek to ascertain the peculiar physiology of the thing, then its proper designation is the key that unlocks many of the secret places of the law connected with it. Section 132. This question may be asked, if labels, e.g., are not technical trademarks, why permit evidence of their contents to be introduced? as is done in many cases. For this reason, although labels are not constituent elements of trademarks, and are but vehicles for the same, all the details may be proven as surrounding facts, circumstantia, and should be brought forward as witnesses of a fraudulent intention. It must be conceded that anyone may lawfully copy another's signature, or emblem of personality, and may publish it to the world. But if, in addition to the act of imitating, he use it in a peculiar manner to obtain a false credit, as by applying it to merchandise intended for sale, then his intent may be inferred from all the minor facts. The maxim, nociter associis, is applicable. It is known by its companions, it is discoverable by what precedes and follows. Section 133. We know that mere labels, notices, advertisements, and business cards possess none of the essential characteristics of the common law symbol of trade, and therefore are not entitled to registration. For that reason, a label reading, "For sale at record office, Topeka, I," or one with gold medal clothing, "For a legend to be affixed to wearing apparel," or Sencas waterproof tags and labels, or the name of manufacturer, place of business, and description of goods, stenciled or painted, or labeled on said goods, would be rejected by the Patent Office as not being technical marks of manufactures or commerce. Section 134. In one case, the applicant, a corporation created by authority of the state of Pennsylvania, for the purpose of manufacturing and selling fruit jars, bottles, and other vessels which are automatically and hermetically sealed when full, claimed the simple name of valve jar, which was the true name of the thing made and sold by them. Those words on a label could not have the magical effect of transmuting the label into a thing of another nature. The application was rejected. So, also, where the proposed mark consisted of the words musical note paper, and the name and residence of the manufacturers of a certain kind of note paper. A few bars of music were printed upon the first page of each sheet, as a fanciful heading. The counsel ingeniously argued that there was nothing descriptive in this designation, as the paper could not truly be termed musical, and that the words were not a mere label, but in verity were an arbitrary symbol, a good trademark. Rejected. Section 135. The words Johnson S. American Anodyne Liniment shared the fate of the preceding case, and upon the same grounds. The answer to the application was that any person by the name of Johnson has a perfect right to make and vend liniment, anodyne liniment, American liniment, and, in offering it for sale, to call it by its proper name. The right to the use of the combination of words not being exclusive, said words could not be a trademark, being merely a label or advertisement, and nothing more. Section 136. A slight degree of hesitation was felt in rejecting the words true-fit shirts, and cable-stitched kid gloves, but upon reflection it was decided that these combinations of words expressed the correct names of the articles to which they were affixed, and were but the use of ordinary language, free to all who sell true-fitting shirts and gloves made with the cable stitch. Section 137. And still more hesitation was experienced when were filed the words James Hennessy, Cognac, 8 as a mark used upon brandy by the applicants or their predecessors in business for 55 years. This seemed to be a matter of hardship. Yet for more than half a century the firm had mistaken a mere label for the time-honored, dignified trademark. Remedy for its violation must be sought under local laws, or under the general powers of a court of equity for unfair competition in trade. Section 138. If one claim titles of firms, or names of manufactures, to which he shows no vested right, he will not be deemed to possess even a label. As an instance of persons seeking their own discomfiture, while swelling the revenue of the Patent Office by $100. Read this. For applications, claims, the words Bristol Watch Co., Bristol, Mass. G.M. Wilson, Chicago, Ill. New England Watch Co., Providence, R.I. And Chicago Watch Co., Chicago, Ill. These names, said the applicants, are used upon watches and watch movements, and this same petition states that no other person, firm, or corporation has a right to the use of said trademarks, or of marks substantially the same, not even substantially the same. Rejected. Section 139. What is merchandise? This seems at the first glance to be a puerile question, and yet it is one that has sometimes puzzled experienced men of business. We all know that it means the objects of commerce, whatever is usually bought or sold in trade, or market, or by merchants, wares, goods, commodities. Yet a case may easily be supposed where the question cannot be answered without hesitation, when considered in its relation to a trademark. Section 140. This question came up in the Patent Office, in 1872, in an application for a design, patent for a label with a coupon attached. The whole value of the label depended upon the peculiar configuration, and was intended to be sold to manufacturers of a certain kind of paper collars, and c. He who bought that label thereby obtained a license to sell that particular kind of goods, and at the same time he had furnished to him a certificate of good workmanship. Now, what was intended to be sold? It was the label. But the label would have been incomplete without a peculiar mark. Then that peculiar mark could not be considered to be a trademark, strictly speaking, for a trademark is merely the index to something that is offered for sale. In this case, it was actually incorporated into, and became an essential component part of the commodity. That answers the requirement of the law in relation to designs. The label was a design, a matter of configuration of a new and useful article of manufacture, and without the peculiar mark it would have no more served its destined purpose than would a college diploma without signature. After deliberation, the matter was decided to be a design. Section 141. In the Court of Paris, in 1859, Lalande et al. V. Appellate ls. It was decided that tickets or labels, composed and sold by a lithographic printer, could not be considered as trademarks. The plaintiffs, lithographers, complained that the defendants had counterfeited the designs upon tickets or labels destined to be sold to vendors of liquors and cosmetics, to be placed by them upon flasks or bottles. The defendants, as a point of law, contended that the plaintiffs had no right to recover, for the reason that the designs upon the tickets were neither designs of manufactures, nor marks for the same in the sense of the law of 1793. The reasoning of the court is perfectly convincing. Among other matters, it was held that the plaintiff's claim was ill-founded, because the tickets in question were the special objects of their commerce, and therefore could not be regarded as trademarks, that the trademark, regulated by the law of the 25th of June, 1857, is the characteristic sign by means of which commerce distinguishes the products of fabric or objects of commerce, that the mark itself cannot be an object of commerce, that, by the use which a merchant makes of a ticket, in applying it to a vase containing the product of his manufacture, it is possible that the ticket may become for him a trademark, subject to the fulfillment of all legal formalities, for it may be then, as to him, a sign or distinctive seal of his products, without being the very object of his commerce. But, as to the plaintiffs, the tickets can be nothing but the special object of their industry. Judgment for defendants. On appeal, the decision was affirmed. Section 142. The same question was considered in a case in the Patent Office, where a lithographer applied for a trademark to be affixed to labels manufactured and sold by him to merchants and others. It appeared, however, that he intended the mark to be stamped or printed upon the label, not as a constituent element, but as a sign of authenticity. Under that view of the matter, a certificate of registry was allowed. Section 143. Essential characteristics. There are certain infallible indicia of the nature of the symbol known to commerce and jurisprudence as a trademark. These are, invariability, that is, fixed, positive, unmistakable, individuality, such a difference from other symbols as to indicate origin and ownership. 3. Universality of a right to its use, that is, good as a representative of, or substitute for, the owner's signature all the world over. 4. Exclusiveness of the right to use. 5. Application to merchandise. 6. Use in lawful business. 7. Truth and good faith. 8. Duration unlimited but by the trade itself. Protection, however, may sooner cease.